Hey folks, Keith Stickley with the Stickley Law Firm here at our new office in Hillsdale, Michigan. I am a Michigan criminal defense attorney, and today I'm going to take some time out to have a discussion with you guys about what unfortunately has become one of the most common legal problems that many people have during this time of the year. We're sort of in the winter, the holiday months, and that is domestic violence. And domestic violence in Michigan it's a very serious crime, and it's something that you need to take very seriously if you are, in fact, charged with domestic violence. But today we're going to sit down, we're going to have a seat, and we're going to discuss what a domestic violence act actually is, what are our options, and what you need to do if you find yourself in this predicament. So here at the Stickley Law Firm, every single year around this time, we are inundated with calls and questions about domestic violence, mostly from people who have been charged with domestic violence, or maybe one of their loved ones has been arrested for domestic violence. And now they find themselves scouring the internet, asking friends, calling lawyers, trying to figure out what is going to happen and what they need to do next. And the interesting thing about domestic violence is that this is probably the one crime, the one serious crime that people find themselves caught up in, these serious charges they find themselves caught up in when they have had no previous experience with the criminal justice system ever. We have just found that, domestic violence is one of those things that it pops up out of nowhere in emotionally charged situations where there's often, quite frankly, quite a bit of alcohol, and those things happen in the holidays. So it's not uncommon for somebody to get arrested and charged with domestic violence, and they don't really know the system, how the system works, what they should do next, because they've never had any sort of legal problems. Up until this point, they've lived their life as a totally, reasonable, rational, law-abiding citizen, and then this thing falls in their lap. Now, brief disclaimer before we get into this stuff. This video doesn't constitute any sort of a lawyer-client relationship. I am a criminal defense attorney here in the state of Michigan. I'm only licensed in the state of Michigan, and I do some federal work, but that doesn't have anything to do with this. It's important that you seek out an attorney that you trust, you feel you can work with, for unique insight into your actual case. If you're anywhere in Southwest Michigan, you're more than welcome to give me a call. We'll help you out as best we can. But I make these videos because a lot of times I find it handy if people, even before they come in, they sort of have an idea of what they might hear or an expectation. And quite frankly, it's nerve-wracking when you maybe you just got bonded out of jail, or maybe somebody that you care about is going through this, and you want a little bit of understanding about the process and sort of what's going to happen. So I'm going to break it down and give you some options, because there are some interesting options and ways to sort of mitigate the domestic violence charge problems, short of going to trial, that can end up leaving you with a totally clean record. So we'll get into that. So to begin with, and it's going to be a little bit of a longer video, so bear with me, but I think it's important that we sort of define some terms, okay? Because people don't really tend to know what domestic violence is if they don't have any experience with this. So domestic violence in the state of Michigan is an assault and battery, or a battery by a spouse, a former spouse, a person living in the same household, but maybe not in any way intimately, a person that has a child in common with an alleged victim, or a person who the victim or alleged victim has had a dating relationship either currently or in the past. This part is, in my mind, a little bit of controversial, and we don't really have time to go down that rabbit hole, but Michigan has taken a really, really wide approach to what the definition of domestic violence is, and that sometimes makes it extremely challenging to deal with once you've been charged. So now that we know kind of who the alleged victims could be, or how that target is, what do we mean exactly by an assault or assault and battery? Because oftentimes, one of the first things I hear when people come into my office is they say, "This is ridiculous. They charged me with domestic violence, and I never hit or I never touched him or her." And I do say him or her because domestic violence traditionally was always seen as like, the nasty, mean boyfriend, beating up on the girlfriend or whatever. We are seeing a massive increase in the amount of both same-sex domestic violence occurrences and female on male domestic violence charges. So don't think for a second it's just the guys, because we're seeing just as many in a very growing, disturbing trend. So an assault or an assault and battery. Assault does not mean physical contact, believe it or not. All an assault means is that you put somebody in fear of imminent harm or contact, but it doesn't have to actually be physical contact, okay? You can assault somebody with words, depending on the situation. You can say things and act things and kind of puff up in a way that would put a reasonable person in fear of imminent harm or danger, and that's an assault. And that can be considered domestic violence if the relationship between you and that person meets the statutory burdens that we talked about. And then there's, of course, the classic assault and battery, which is, words lead to actions and unwanted touching, and battery is basically an unwanted touching by somebody. So that's what it is. So can you be charged and even convicted of domestic violence without physical contact in Michigan? Yeah, absolutely you can. And that's what makes defending these sometimes so, quite frankly, so complicated and really challenging. And so it's something that we focus on. All right, so now that we know what domestic violence is, why is it so important to defend yourself against it? So domestic violence is a first offense if you've never been arrested or anything like that. Domestic violence is a 93-day misdemeanor. Now, what is a misdemeanor? A misdemeanor is a crime in Michigan that you can only, in this case, be sentenced to jail for a maximum of 93 days in jail, okay? There's no prison available for domestic violence as a first offense. And I'm going to tell you, going to jail for 93 days is extremely, extremely rare in Michigan. It is possible, depending on the circumstances and the sentencing judge. But it's not something that you can go to prison for. Probation, however, in Michigan is extremely, extremely likely. And along with probation, sometimes various counseling and that kind of thing goes. Now, if you've been convicted of a second domestic violence in the state of Michigan, the judge can sentence you up to a year in jail. And we see that does happen sometimes. That is kind of common. If you're charged and then convicted with a domestic violence second offense, you're definitely going to need some legal help, be it our office or whoever. It doesn't really matter. If you meet the statutory requirements for indigency, you'll be assigned a public defender. You're going to need some serious legal help. Also, if it is considered an aggravated domestic violence, what does aggravated mean? They can charge you as an aggravated domestic violence if the alleged victim required some form of medical treatment, or if there was some sort of a substantial injury, okay? That's when you come in, somebody gets pushed through a window and they have to go to the hospital, they're bleeding, that kind of thing. If you are charged and convicted with a domestic violence third offense, or you have any more than two on your record and you get another one, you will be charged as a felony, all right? That is a 5-year felony. All the requirements are exactly the same for a domestic violence third. It doesn't make it any worse or whatever, but it's a charge based solely upon your previous record. So if you already got two, they can charge you as a felon. And that's a whole nother ball of wax. That takes you out of the district court. All criminal cases start at the district court in Michigan. But ultimately, it's very likely that the case will be resolved in the circuit court. And I can tell you, almost always, in my experience, domestic violence thirds ends up in jail time at a minimum. There are people in the Michigan Department of Corrections in prison for domestic violence third. And if you are charged with that, you have to seek extremely competent legal counsel because there are strategies and things to protect your rights that are absolutely essential, that can truly alter the trajectory of the rest of your life. Really, any of these can, but prison's a whole nother ball of wax. So, although only domestic violence third is the felony, I often tell my clients that come in, even in domestic violence first, you do have to take extremely seriously because unlike almost every other misdemeanor in the state, a domestic violence conviction, even the first conviction, has ramifications to a lot of generally law-abiding citizens that felonies have. For instance, you can't possess or carry a concealed firearm, and in some circumstances, and under some interpretations of the law, and it's not a rabbit hole I'm going to go down today, but if you have these issues, come in and we'll explain them. It can actually bar your ability to exercise your Second Amendment rights. So if you are a hunter, if you are a concealed CPL holder in the state of Michigan, just a simple CPL, a simple domestic violence will greatly affect your CPL. So you gotta handle these things quick. You gotta work with an attorney quick and get the ball rolling in your defense. Now I'm gonna walk you kind of through what actually happens in the stereotypical domestic violence world. Okay, we're gonna make a couple assumptions for the sake of conversation. We're gonna assume that you have never been really arrested before because you're a law-abiding citizen, and we're going to assume you've never been arrested before and you don't know how this whole thing works, okay? So the stereotypical scenario that we see is that it's usually around the holidays, in an afternoon, maybe somebody, let's assume that the person being charged with the domestic violence is a felony and is a male and his name's Fred and it's his first conviction, and we got Susie as the alleged victim. So Fred and Susie are at home. Fred doesn't want to go to Susie's in-laws. They've already had their marriage has been a little rough. They've had a little bit too much to drink, and an argument ensues because Fred doesn't want to go to Susie's parents' house. And the next thing you know, they're screaming at each other. Okay. And then, who knows? They get a little too close, and Fred maybe bumps Susie somehow. And maybe there's even after that, there's some sort of mutual combat. Maybe there's some physical contact. And Susie calls the police. What's going to happen? Well, assuming that the police show up, they're going to immediately separate the two people, and they're going to get their stories, okay? And the focus, in my experience, is, of course, on the alleged victim. Susie, what happened? What happened? Where did he hit you? Are you hurt? Tell us the whole scenario. And she's going to give her whole scenario, right? Her whole side of the story. And then they're going to go to Fred. And they're going to say, Fred, what happened? And now Fred's got to make a decision. Does Fred talk to the police and make statements? Or does Fred be quiet, okay, and let the chips fall naturally where they may? I'm going to tell you right now, 9 times out of 10, regardless of who's at fault, Fred is going to be placed in handcuffs and taken to the jail for booking and charged with something. So many counties in the state of Michigan actually have a policy. They might not even have it written down, but to say that they don't have a policy is ridiculous because they all do this. They feel the need to separate the couple because they don't want the situation to inflame, okay? So they will book somebody. Somebody's getting arrested. Somebody's going to jail. 8 times out of 10, 9 times out of 10, let's be real, it's going to be Fred, okay? It is imperative for the Fred at this point, okay, to be calm, respectful, and not talk a lot. All right? Why is that? Well, I can tell you, having won multiple domestic violence trials and settled hundreds of, not thousands, but at this point maybe, of domestic violence cases, I can tell you, nobody ever talked their way out of being charged with domestic violence while talking to police on the front yard of their house. Ever. It just doesn't happen. It just doesn't happen. The police so often take the attitude, and I understand why. I'm not totally knocking them for this. I kind of am, but I understand why. Because they don't want to get involved in that. They don't have the training. They don't have the time. They don't have the resources to figure out and untangle that ball of wax, right? They want nobody to get hurt, and they want to go home safe to their family. So Fred's going to jail. Susie's going to stay in the house, and we're going to figure it out later. It is imperative at this time that Fred not resist or give the police gruff, because here's another thing that we see all the time. If you resist being arrested, you will be charged additionally with a 2-year felony called resisting and obstructing a police officer, R&O, as we call it in the business. The problem with getting an R&O is that takes only having to deal with a 93-day misdemeanor, no problem. Maybe we have valid defenses. Maybe Fred's truly innocent, right? But the second he elevates it with the police, now he's being charged as a felon. And if he is going to get aggressive with the police, how do you think the rest of them is looking? What is the rest of the world looking at him like when he's going to go plead his case that he wasn't being violent, against Susie? So that's something that we see tag along together all the time. And it makes our life extremely difficult as a criminal defense attorney. And quite frankly, it makes our clients' lives, it makes their legal bill on that a lot more expensive. It's complicated. And they are definitely opening themselves up to jail if they resist and obstruct a police officer during their investigation of a domestic violence. So we don't get involved in confrontations with the police. We do our argument, we do our fighting in a courtroom in a legal way with trained professionals. That's what I do, that's what my firm does, that's what my colleagues do. Regardless if you bring me into it or another attorney, we fight in the courtroom. That's what we do, okay? All right. So the second that they take you to the jail, Fred's gonna get photographed, fingerprinted, all that stuff. He's probably gonna have to sit in some little holding cell. And he might have to wait for a thing called an arraignment. An arraignment is the very first hearing you're gonna have in front of a judge, okay? And there should be, under Michigan state law, there should be a public defender there just kind of on call, just to sort of protect your rights. Not really defend you or get into the case, but just immediately protect your rights. And that attorney, hopefully, if they're decent, is going to try to argue for what's called a PR bond, a personal recognizance bond, where you don't have to actually post money to get out of jail. You're just going to sign papers, and they're going to give you a court date, okay? If you qualify for a public defender, if you truly can't afford your own attorney, they're going to probably give you some of that paperwork then as well. And that's actually what starts the ball rolling. So hopefully, you can get out on a PR bond. If you can't, you're probably going to have to post some bond, some monetary money to ensure that you're going to arrive to court. The other thing that's going to happen, and this is extremely important, is you're going to have a no contact order with the alleged victim. What does that mean? Well, that means that Fred will not be allowed to have any contact whatsoever with Susie for any reason until the judge says so. Now, this presents huge difficulties sometimes for people in relationships, where maybe there's one vehicle and there's children involved and bills need to get paid. I get it. It becomes a massive hardship, but there's no way around it outside of doing it the right and legal way. So, the judge, I don't know of hardly any judges or magistrates that conduct arraignments that don't institute a no contact. This is also important for people with CPLs. If you have a Michigan CPL and a no contact order is put in place by a judge because you've been charged, you're still innocent, but just because you've been charged, your CPL is going to be revoked or at the very least suspended during the course of the trial or case, however it ends up. So you're not going to be carrying, and you're not going to be buying a gun. And that is, by the way, a federal law as well as obviously state law. You can't have any third-party contact whatsoever. Fred can't contact Susie. So Facebook, Instagram, cell phones, message, notes left on the door. You can't do it. I have seen guys try to slip their wives or significant others notes and such and get held in contempt of court, get in more trouble, and have to do more jail time because they did not follow a court's no contact provision than they would have if they just pled guilty to the crime, paid some money, and moved on with their life. It is that serious. So how does this no contact thing work if you've got all this other stuff going on? See, a lot of times that we've noticed is that an alleged victim might be, let's say, quite a bit at fault as well. And they realize that the situation was blown out of proportion and they want the thing to go away. They don't want the no contact. They don't feel threatened at all by the person. And so it puts us in a weird quandary. What do we do? And how do they change it, right? We get calls from alleged victims all the time to our office. You got to get this no contact dropped. Or I got to talk to Fred. Every county does it differently. But if you are working with a competent attorney, oftentimes that attorney can reach out to any alleged victim, or the victim can reach out to that attorney to have a discussion. That is not a violation of the no contact order. So if somebody retains me to defend them as their attorney, I and my staff or my investigator, I work with an investigator quite a bit, can actually reach out to interview potential witnesses. And guess who's a potential witness? They're not even the potential witness, they're the complaining witness, but they are a witness, the alleged victim. So we can get information, and it's not a violation of anything. And sometimes that's extremely, extremely handy. Quality attorneys will know how to reach out in legal and ethical ways to see what the mindset or the position of the alleged victim might be. There's also an agency in most counties in Michigan called a victim's advocate representative. And they're usually somehow embedded into the prosecutor's office. We like to call that the Department of Sympathy, sarcastically amongst criminal defense attorneys. But their job is kind of to get the victims, well, their job is to provide support for the victims, if you will. A lot of times it feels like their job is to try and convince the victims to testify against, the defendant. That's just how it works. And I guess I understand why. I understand that bias. It makes sense. But a smart attorney defending you will reach out to that victim's advocate and say, hey, look, what is the victim saying? Like, do you know what the victim wants? Does the victim want this guy to get psychological help? Does the victim want this case to go away? Being able to have those conversations with a victim's rights advocate can provide incredibly valuable information that can help a defendant, and quite frankly, help the alleged victim as well. It is a little bit frustrating. Some alleged victims end up being combative with the victims' rights coordinators, and it's these are emotionally charged situations, and we know how to deal with that, and a lot of other attorneys do as well. But bottom line, you can't have contact until a judge says yes. In Hillsdale County, there's a relatively standard procedure. A lot of counties are like this as well, that basically the judges in Hillsdale County want you to get a safety plan. Let's say that you're an alleged victim and you don't feel threatened, maybe you don't even agree with the case, what you're going to want to do is you're going to want to reach out to whoever the defendant's attorney is, or the victim's rights advocate, and ask, how do I develop a safety plan that we can present to the judge to get this dropped, and here's why. And so like here in Hillsdale, I think they go to, I apologize, the name just fell out of my head, but it is it's basically a group home it's like a battered women's shelter. And they do really, really good work. And they have counselors there, and they know kind of what they're doing, and they're familiar with the system. And they'll literally sit down with the alleged victim and go over and say, hey, look, if you go back into this situation and something happens that makes you feel unsafe, let's pre-plan what steps we're going to take to make sure that you're safe. Call the police, go to this location, call a counselor, call pretrial services, let them know, let the courts know. And what they found basically is that people having a safety plan gives people a lot of comfort, and really does provide for, if the unthinkable happens, where there's another kind of assault or something like that, they know what to do, and it lessens their likelihood of becoming, injured or anything like that. So that's how that goes. If you, if you are watching this video and you're the alleged victim of something and you want to get the no contact dropped, you're going to have to talk to their attorney or a victims' rights coordinator, and they'll try to help you. All right. So let me describe one other scenario. This is a little bit rare, but this happens. And there's a lot of prosecutors in Southwest Michigan who have, I don't know if it's just an incompetent staff or understaffed or whatever, but they'll arrest somebody and then they won't actually formally charge them with domestic violence, or they'll issue a warrant after they've already left the jail, and months can go by, right? Months can go by. And then they find out, they get pulled over for a, I don't know, taillight out or something, and they find out there's an arrest warrant for them for a domestic violence charge. And maybe they've been living with the domestic violence, the alleged victim, for a long time. And suddenly they want there to be, the judge wants there to be no contact. Well, hell, maybe they've been living with each other for 6-8 months and everything's fine. This is a one-off thing. Those can be really complicated scenarios. And I don't have a magic bullet that will fix that scenario. All I can suggest is get competent counsel ASAP to try to work through some of those issues. And some of those issues can be dealt with quickly if you're working with somebody that knows what they're doing. So that's kind of crazy. All right. So now that you're bonded out, okay, Fred's bonded out of jail. Now what's going to happen? Well, assuming that he's only being charged with a domestic violence as a first offense, which is generally what happens, there's going to be a thing called a pretrial conference. And the pretrial conference is sort of the first formal time that the defense attorney and the prosecutor get together. They sort of exchange evidence. They make sure that everybody has all the information, and they have a frank discussion over what are the needs of this case, and can this case be dismissed? Is there going to be some sort of a plea offer? Are we going to go to a trial? There's basically two paths. That's not really true. I'm going to say there's three paths. There's three paths to a domestic violence case. Path number one, Fred's totally innocent. The prosecutor won't drop the case, and nobody will listen, and it's the prosecutor's burden to prove beyond a reasonable doubt that Fred's guilty. So we go to a jury trial, all right? And in a jury trial, we have to convince 6 of the people who are too dumb to figure out a way to escape jury duty that Fred is not guilty. Actually, that's not really what we do. We actually convince the jury that the prosecutor has not met the burden. In other words, they haven't met the burden showing that Fred is guilty beyond a reasonable doubt. That's option number one. Option number two is maybe there is some sort of a plea deal. Maybe the prosecutor, in exchange for Fred taking responsibility for what he did, maybe they will give him a lesser charge. All right, that's number one. Maybe they'll guarantee, look, Fred, if you admit this, we will tell the judge we recommend no jail up front as long as you go to your counseling. You go to like an anger management class or something like that. That's very common. And you're on probation for a little while, okay? Option number three is a really, really valuable option. And sometimes prosecutors tell everybody up front, this is the only option they give. Option number three is a thing called a 7694A deferral. Michigan law under MCL 7694 Section A says that if a person has never been convicted of a domestic violence crime before, it's their first offense, and they successfully complete probation, the entire case will vanish and go away like it never even happened. Now, this is only available to first-time domestic violence people, and I believe there are some other limitations as well. Like you can't have some other A and B or assaultive crime in your past. If that is your situation, make sure you bring that up to your attorney to see if that's even still an option. But a 7694A deferral can be an extremely useful tool, and a lot of times, I don't know how I feel about this. I don't feel great about it, but a lot of prosecutors have a policy that there's only 2 ways that they'll deal with domestic violence, regardless of the facts. They'll either try the case, they'll either try a jury trial, or they'll offer a pretrial offer, a plea, that will include pleading guilty or no contest and giving them a 7694A option. The problem with that is sometimes the people are just innocent, and you got to look at the whole situation, with your brain, and say, no, whatever happened, maybe something did happen, but whatever happened here does not rise to the level of a crime. But, because of our prosecutorial policy, we're not going to dismiss it. And that's really unfortunate, because a prosecutor's job is not to win at all costs. It's really to find true justice. And so many prosecutors don't do that. And maybe a little flack for that. But, it's easy to accuse somebody when you're not there, and you don't have to see the defendant as human. And, everybody that gets charged with a crime is a bad guy. And that's really a prevalent attitude, whether they want to admit it or not. I see this every day. This is what I do. But I digress. It is what it is. So you can only play the cards that you're dealt. So your attorney's going to tell you straight up going into these situations what kind of prosecutor, what kind of offers we're dealing with. And the things that I consider when I'm looking at these kind of cases in determining whether or not I should suggest that we go to a trial or not is, what's the victim's credibility like? And that's where things like having a private investigator come into play, and talking with the victim's rights coordinator. Was there any witnesses? Was there really any injuries? Is the alleged victim willing to cooperate with the prosecutor? It's amazing to me how many times we are able to find through our investigator or the victim's rights coordinator that the victim doesn't want to cooperate with this prosecution at all. And some of these prosecutors, they don't even care. They'll keep plugging forward saying, "Oh, no, I gotta take it anyway." And I think that that's a massive, massive miscarriage of justice. But it is what it is. And in those cases, if you're truly innocent, then you're going to go to a trial, and you're going to roll the dice and do it. I happen to enjoy trials. I think that they're challenging and whatnot, but it's a roll of the dice. It's always kind of exciting. So what happens? Let's say Fred goes to a jury trial. Like, what happens at that point? Let's say he loses. Well, if Fred loses the jury trial, he's going to be convicted of a domestic violence, and they're going to do a thing called a pre-sentence investigation or interview. And it's going to be basically like a recommendation. The judge is going to sentence him. The judge can give him probation. The judge might give him 30 days in jail. There's a lot of different options, a lot of community service. It's not uncommon for judges to sentence people to anger management classes, and sometimes if alcohol was involved, or is even mentioned in the police report, I've seen a lot of judges want to see a substance abuse evaluation to see if somebody has a substance problem. Fred could win the trial. If Fred wins the trial, we shake hands when we get the not guilty verdict, which is always a good and interesting feeling. And I enjoy. We shake hands, usually half hug. Fred walks out of the courtroom, and everybody goes on about their business. And then there's a 7694A. If you enter a plea, usually I will be the one on the record to ask my client specific questions, and I ask them in a specific way, because you're going to need to establish what's called a factual basis, basically making admissions on the record. And you want to do that in a certain way because you don't want to expose yourself to any other future liability. And then you're going to do probation, and at the end of the probation, paperwork gets filed, and the case becomes non-public. It goes away like it never even existed. So those are the three and a half, if you will, main options of the ways that these things can go. And it's scary. It's scary for people to be accused of a crime when they've lived their entire life, and they don't think that they've done anything wrong, or maybe they made a mistake and they're looking to sort of, minimize the bad consequences, but they want to improve themselves and move on with life. It's something that we take very seriously here at the Stickley Law Firm. Our goal, regardless of the outcome, is when people walk into our office, we try to make sure that they leave in a better position than when we found them. That's sort of something that we pledge to do. And so domestic violence charge does not have to be the end of the world. It's something that can be both fought, because I'll tell you, a lot of people are completely innocent to get charged with domestic violence. A lot of people. And it's hard sometimes to sit in court and watch guys plead to stuff and make admissions when it's like, I wouldn't do that, man. I wouldn't do that. But it is what it is. We're attorneys, and we can only advise our clients of what to do and what is in their best interests. We can't do that work for them. And that's something to keep in mind too. Your attorney, regardless if it's me or anybody else, is not going to be a miracle worker. We've got to play the cards that we're dealt. So that is it for domestic violence, especially domestic violence as a first offense. Hopefully that's given you a little bit of insight into kind of what happens and sort of the anatomy of a domestic violence case. It's so, so, so important. Let me just close with this by saying, especially around the holidays, when emotions are high, when alcohol is being consumed, when you're sometimes around people that are not your favorite family members and other folks, if you find yourself getting into a disagreement or an argument over anything, I'm talking politics, religion, cars, some former memory that you want to debate about, be careful. And if the voices start to raise, okay, take a deep breath and remove yourself from the situation. Remove yourself from the situation. being awkward and kind of having a ruined holiday or ruined experience with somebody that you care about for one day is such a smaller, insignificant event than once the criminal justice system gets involved and cuffs are going on, and then you have to deal with an attorney like myself or a colleague to try to keep you out of a cage. It's just not worth it. It's not worth it. And if you're the kind of person that consumes alcohol or other substances and it makes you not a nice person, you gotta know when to walk away. You just gotta walk away. And God forbid you end up in this situation, the cop is not the guy to fight with, right? He's just doing his job. He just showed up. Yeah, he might be a jerk. He might be a dirty cop. He might like arresting people and hurting people. There are a lot of bad cops out there. There's quite a few good cops out there too, but they don't want to deal with your personal mess. Somebody's going to the jail. That's going to enforce the separation, and then you got to deal with it. And there's right ways to deal with it and wrong. So if you are somebody that you care about, find yourself in this situation, and you need some legal help, give my office a call. The Stickley Law Firm, my office is here in Hillsdale, Michigan. We'll help you out as best we can, and if we can't help you, we'll point you in the right direction. Be well, stay safe, and we'll talk to you soon.